Many questions from ethical and legal issues have come up on recent examinations. Students need to learn why something is right. We do this by applying the rules for ethical and legal issues, just as we did for physician-patient relationship. There are 5 very important court cases. We don't need to cite the cases by name, but we should know the rule that we get from each one and apply it to ethical issues. The first one is the Carrie Ann Quinlan case, and this has to do with substituted judgment standard. Karen Ann Quinlan was an important figure in the history of the right to die controversy in the United States. When she was 21, Quinlan became unconscious after arriving home from a party. She had consumed diazepam, dextropropoxyphene, and alcohol. There's disputes about these substances, but that is what is presumed. After she collapsed and stopped breathing twice for 15 minutes or more, the paramedics arrived and took her to the hospital, where she lapsed into persistent vegetative state. After she was kept alive on a ventilator for several months without improvement, her parents requested the hospital to discontinue active care and allow her to die. The hospital refused, and the subsequent legal battles made newspaper headlines and set significant precedents. The New Jersey Supreme Court eventually ruled in her parents' favor. Although Quinlan was removed from mechanical ventilation during 1976, she lived on in persistent vegetative state for almost a decade until her death from pneumonia in 1985. So therefore, the court allowed termination of life support, not because the father asked so, but because it held that the father's request was most likely the expression of Karen Ann's own wishes. This is very important when the proxy or the next of kin in a patient is asked what would they like for the patient. It's not what they would want for themselves, but what they think the patient would want for themselves, just like Karen Ann Quinlan wanted for herself. It wasn't her father that wanted this, but it was she that wanted this, and her father telling the court so. Remember, they did not want to end Karen's life, but to end the extraordinary means, specifically the ventilator, and they assumed this is what she would want for herself. The next case is the Brother Fox case, and this concerns best interest standard. The Brother Fox case was an issue about a terminal patient's right to refuse extraordinary means of life support, or to have them refused on his or her behalf. Brother Joseph C. Fox was an 88-year-old member of a religious community who had fallen into a coma after a cardiac arrest that occurred during a hernia operation. In the wake of the Karen Quinlan case, Fox had expressed a strong desire not to be kept alive by extraordinary means. This was documented by people of his religious community. The court then appointed leaders of his religious community, a committee of the person of Brother Fox, and authorized them to have the respirator removed. They did so, and on January 24, 1980, Fox died of congestive heart failure. This case brings out the best interest standard, meaning that if the patient has always been incompetent or unable to tell us what he or she wants, and no one knows the patient well enough to render substituted judgment, then under these circumstances, decisions are made for the patient using the best interest standard. That means what a hypothetical, reasonable person would decide to do after weighing the benefits and burdens of each course of action. The third case is infant Doe, and this concerns foregoing life-saving surgery. There have been many infant Doe cases, but the most important one occurred as baby Jane Doe that brought the issue of withholding treatment for newborns with disability. Baby Jane Doe was born in October 1983 in New York City with an open spinal column, a meningomyelocele, hydrocephaly, and microcephaly. Surgical closure of the defect and reduction of fluid from her brain would prolong her life, but she would be bedridden, paralyzed, epileptic, and with severe brain damage. The parents consulted specialists, clergy, and social workers, they decided to treat the newborn with antibiotics and bandages rather than surgery to repair the defect. As a general rule, parents could not withhold life or limb-saving treatment from their children. Yet in this exceptional case they did. An application of the best interest standard. The court agreed with the parents that the burdens of treatment far outweighed any expected benefits. The fourth case has to do with Roe versus Wade, and this concerns that the patient decides on the outcomes. Roe versus Wade is a landmark decision by the United States Supreme Court on the issue of abortion. Decided simultaneously with a companion case, Doe versus Bolton, the court ruled 7-2 that a right to privacy under the Due Process Clause of the 14th Amendment extended to a woman's decision to have the abortion. They also said that that right must be balanced against the state's two legitimate interests in regulating abortions, protecting prenatal life and protecting women's health. But the bottom line is that in the United States, based on this Roe versus Wade, the focus of the decision-making about health care resides with the patient, not the physician, and not the patient's family. The fifth case is the Tarasoff decision, the duty to warn and the duty to protect. This is a landmark court decision, again in California, which holds a mental health therapist responsible for being proactive in preventing harm by a particular patient. If the therapist knows or has reason to suspect that the patient may present a risk of harm to a specific person or persons. And this decision not only holds true for a mental health therapist, a psychiatrist, but also any physician. Mr. Podar was a student from India, and he entered the University of California, Berkeley, as a graduate student in 1967. He fell in love with this woman called Tatiana Tarasoff. They saw each other weekly throughout the year, and he interpreted that because she saw him and kissed him at some point, that they had a serious relationship. This view was not shared by Tarasoff, who, upon learning about his feelings, told him that she was involved with other men and otherwise indicated that she was not interested in entering intimate relationship with him. This gave him feelings of resentment, and he began to stalk her and apparently developed a wish for revenge. Mr. Podar then went to see Dr. Moore, a psychologist at UC Berkeley Memorial Hospital. Podar confided his intent to kill Tarasoff. Dr. Moore requested that the campus police detain Podar, writing that, in his opinion, Podar was suffering from paranoid schizophrenia, acute and severe. The psychologist recommended that the defendant be civilly committed as a dangerous person. Podar was detained shortly, but thereafter released as he appeared rational. And Dr. Moore's supervisor, another physician by the name of Dr. Poulsen, then ordered that Podar not be subject to further detention. Several months later, Podar carried out the plan he had confided to his psychologist, stabbing and killing Tarasoff. Tarasoff's parents then sued the university and the psychologist and various other employees of the university. And Podar was subsequently convicted of a second-degree murder. The point, of course, of the Tarasoff decision is that in situations where someone is in danger, we have to first try to detain the person making the threat, next call the police, and finally notify and warn the potential victim. All three actions should be attempted. At the time, the California Supreme Court found that a mental health professional has a duty not only to a patient, but also to individuals who are specifically being threatened by a patient. This decision has since been adopted by most states in the United States and is widely influential in jurisdictions outside the U.S. as well. After discussing the 5 major cases that give us the structure concerning ethical issues and legal issues, we have to talk about the different rules. Rule number 1 is that competent patients have the right to refuse medical treatment. Remember, in the United States, patients have absolute control over their own bodies. This is very important to remember because in other parts of the world, it's not as clear-cut. The sicker the patient, the lesser the chance of recovery the greater the right to refuse treatment. Refusing treatment is not the same as a suicide attempt. Be very careful. Remember, people say, when we do all these extraordinary measures, are we really prolonging life or are we really prolonging death? So they have the right to say no. A couple of things to remember that are not exceptions when you hear about preserving life. It's like suicide, the sake of third parties, professional ethics. This has nothing to do with that. Patients always have control over their own bodies, and they have the right to refuse all treatments. Rule number 2, we must assume that the patient is competent unless there's clear behavioral evidence that indicates otherwise. Always remember that competence is a legal, not a medical issue. Only courts can decide competence. A diagnosis by itself tells you little about the patient's competence. Be careful. There are diseases, for example, like Alzheimer's, so the patients have severe short memory deficits, but they are still competent to make decisions about themselves and their treatment. Obviously, clear behavioral evidence would be a patient attempting suicide, a patient is grossly psychotic and dysfunctional, then they're not competent, obviously. A patient's physical or mental state prevents simple communication. If a patient is in a coma, well, this person is not competent. In a patient, if there's any concern about competence, if you're unsure, assume always that the patient is competent. If they're making sense, if they're talking to you, assume that the patient is competent. If there's gross psychosis, obvious cognitive capacity preventing communication, suicide attempts and the stuff that we just talked about, then obviously this patient, you could render them non-competent and make decisions. Rule number 3 has to do with who makes the call. Generally, we do our best to try to avoid going to court, and that has to do with us making the call. You, the physician in charge, makes the call. We generally don't call legal counsel. We don't call ethics committee. We may get them involved in certain situations, but those are rare and very few. We don't call them left and right for every scenario we have with patients. And we generally don't seek the advice of another physician to solve our problems. We have to be the ones making our call, and that's the way we answer exam questions. We make the decision. Rule number 4 has to do when surrogates are involved in making decisions for a patient. So this is either that the patient wants them to make decisions or that the patient can't make decisions for themselves. When surrogates are involved, they should use the following criteria and in this order. Number 1, they should use the subjective standard, which means we want to know what the patient said in the past to you or wanted for themselves. Their wishes, not the proxy's wishes, not the surrogate wishes, but the patient's wishes. And that usually is when the patient has talked to the surrogate. The surrogate knows what the patient wants for themselves. This could also come as advance directives. So the patient writes advance directives that the surrogates carry out. The second criterion is substituted judgment. Substituted judgment is who is the best person, if the patient can't make decisions for themselves, to guess what the patient would want for themselves. Let's say the patient has no surrogate, but we want to pick a surrogate. We're going to pick the person that can guess what the patient wants for themselves unless there is some legal surrogate appointed. Also, what's very important in this case is what would they think that the patient would say if he or she was in this situation and they had to make a judgment call on their treatment. And when we talk about surrogates, the number 3 issue here is the best interest standard, which we have talked a little bit about already. The best interest standard means the burdens versus the benefits for the patient. And what would a rational person without bias decide in this case? That's what the best interest standard, and we allow the surrogate to apply something like that. Rule number 5 has to do when the patient is not competent. Then the physician should rely on advance directives. Remember, advance directives can be oral. Oral is enough. A living will is a written document expressing the wishes and really usually applies to end-of-life care. A health power of attorney is designating the surrogate decision maker. Basically, remember what we said before, this person speaks with the patient's voice. Remember, the person that speaks with the patient's voice talks about what the patient would want, not what the surrogate wants. Very, very important here. The health power of attorney beats all other decision rules. That's one of the most powerful things there to apply. Also remember, in the end-of-life circumstances, if power of attorney person directly contradicts the living will, then follow the living will. Always follow what the patient would want. That's the most important. That has the largest weight. Rule number 6 has to do with feeding tubes, and that feeding tube is a medical treatment and can be withdrawn at the patient's request. Remember that a competent patient can refuse even life-saving food and water. This is not considered killing the patient, but stopping treatment at the patient's request. This is very important because, as I said before, in other parts of the world, this doesn't hold. A competent person can refuse even life-saving hydration and nutrition and antibiotics. Please remember that. A competent person can refuse even life-saving hydration, nutrition, and antibiotics. It's not only do not intubate. The only exception to what I just said is people with anorexia nervosa. This person would have to go to court to do something like that. So this violates our previous rule. This is an exception to that, but this issue has never been actually tested on the exam. So please remember that the feeding tube and hydration is medical treatment and can be withdrawn at the patient's request. Rule number 7 has to do with do nothing to actively assist the patient to die sooner. Remember, we said we don't have to make them prolong death, but we do nothing to actively assist the patient to die sooner. Active euthanasia right now and assisted suicide are on very difficult ground. This is not part of the answer, especially on the boards. The best guidance to this is if it's passive death, we allow to die. This is okay. If it's active, this is considered killing. It's not okay. Do all you can to reduce the patient's suffering. For example, give pain medication and give large amounts of pain medication, but do not kill the patient while trying to do so. Rule number 8 has to do with the physician deciding when the patient is dead, specifically about futile treatment. If the physician thinks continued treatment is futile, but the surrogate or the patient insists on continued treatment. Remember, the surrogate is the same as the patient. It's the patient's voice. Then the treatment should continue. In this country, it continues because you give the patient the ability to say no and yes. In this country, that's what matters the most. If there are no more treatment options, the patient is cortically dead, then of course, obviously, treatment must stop. We have to remember that lack of hope versus lack of life. Physicians get to decide lack of life, not lack of hope. So keep that in mind, especially when you're talking to patients. Rule number 9 is a very important professional issue. Never to abandon a patient. You do not have to take a patient on as a patient, but once you do, you must see it through. Lack of financial resources or lack of results are never reasons to stop treatment of a patient and to tell him or her that you have to refer him to somebody else. An annoying or difficult patient is still your patient. And remember, you cannot ever threaten abandonment. So no abandonment for offensive behavior, no even for sexual advances, no lack of payment. These are not reasons to abandon a patient. Rule number 10 is that we have to keep the physician-patient relationship within bounds. Generally speaking, if you think maybe this is not okay, it probably is not. No intimate social contact with the patient. We do not usually date the patient's family. Do not treat family or friends. When patients are inappropriate, help them understand what is appropriate. And generally, we do not accept gifts from patients or their family. And this is on multiple professional sites, not to accept gifts from patients or family. There's a question in one of the books that I saw some time ago, and I think somebody was showing me on one of the internet sites that you can. This is wrong. We do not accept gifts from patients or their family. Remember, physicians should keep their behavior and behavior of their patient in bounds. Rule number 11, stop harm from happening. Remember the Tarasov case. Stop harm to patients, but also to anyone else. Don't let a patient harm someone else. Harm, remember, includes physical assault, neglect, or abuse. Harm could be spreading disease. There's a question about HIV, and somebody who has HIV and infects other people, that you have to tell people if they are going to run the risk of getting infected. Harm could be physical assault, psychological abuse, neglect, infliction of pain, or anything which produces notable distress. You, as a physician, have to do your best to stop harm from happening. You must also protect your patient or anyone, not your patient, from being hurt by another. This is super important. People that are not your patient, that are going to be harmed, you have to protect them. Rule number 12 has to do with obtaining informed consent for procedures. There's 5 parts to this: the procedure itself, the purpose, the benefits, the risks, and the alternatives. And there's 4 exceptions to this: emergency, waiver, incompetence, and therapeutic privilege. So let's talk more about details of those issues. Full informed consent requires that the patient has received and understood 5 pieces of information: the nature of the procedure, the purpose or rationale of the procedure, the benefits of the procedure, the risks, and the availability of alternatives. All alternatives. This is very important because I've seen people get into trouble when they didn't explain this to the patient. There are 4 exceptions to informed consent: emergency, life emergency, or limb emergency, or organ emergency, or something; waiver by patient, usually research or surgery, so they've waived it before because you've gotten another type of consent. Number 3, the patient is incompetent, so then you have to do it, and doing what most people do makes sense here. And then the last one is therapeutic privilege. So it means that unconscious, confused patient, this deprives the patient of autonomy. In interest of health, you could go forward and do the procedure if this is a reasonable procedure to do. Remember, it has to be reasonable. It has to be what most people would do in this case. If somebody would have a myocardial ischemic ST elevation MI, most people would do cardiac catheterization and do percutaneous intervention. That's that procedure. If this person can't consent, that would be a procedure where therapeutic privilege is allowed. A couple things more to remember in this case. Any gag clauses that prohibit a physician from discussing treatment options that are not approved violate informed consent and are assumed illegal. Also, consent can be oral. A signed paper the patient has not read or does not understand, even though they signed it, does not constitute informed consent. If you give them information, this could be oral. But sometimes, if you haven't given them the information, despite signing a piece of paper, somebody comes and says, listen, I listened to this guy give consent from him, and you didn't tell him anything, and he just signed it because he was scared and he wanted to do the procedure, or wanted to do the right thing. That is not considered consent. So the patient has to be informed. And remember, lastly, this was a nice recent question on the USMLE, a written consent could be revoked orally at any time. If the patient says all of a sudden, I had second thoughts about this, they are allowed to revoke consent. Rule number 13, especially rules that apply with children. Anybody under 18 is considered incompetent. There's exception to this. There's what are called emancipated minors, 13 to 17, living as adults, so treat them that way. So if you have somebody under 18, but these people are living as adults, they're having a family, they're working or whatever, they're considered emancipated minors and you have to treat them as adult. This is the exception to the rule that we just talked about before. There's also the possibility of partial emancipation. So in patients, in children, 14 to 17, they can make decisions for themselves in 4 areas, even though they're not living as adults, like the prior fully emancipated minors. These areas, these 4 areas include STD treatment, substance abuse treatment, birth control, prenatal care. Very, very important. Partial emancipation. So somebody comes to you who is 16 and said, look, I want to get treated for STD, or I have this lesion that looks like it may be syphilis. You can consider partial emancipation. This is one of the 4 areas. Prenatal care in young women. This is considered partial emancipation. Birth control is considered partial emancipation. Whether you agree or not to it is a different story, but be careful. For the USMLE, this is considered partial emancipation. You could give birth control to patients 14 to 17 years of age. Be careful about that. Rule number 14. Parents cannot withhold life or limb-saving treatment from their children. Remember, we talked about baby doe. They can in certain situations, but generally they cannot withhold life or limb-saving treatment from their children. If parents refuse permission to treat child, if immediate emergency, you have to go ahead and treat. If not immediate, but still critical, for example, like juvenile diabetes or something like that, generally the child is declared a ward of the court and the court grants permission. If not life or limb-threatening, for example, child needs minor stitches, then generally we try to listen to the parents. Remember, the child cannot give permission. A child's refusal of treatment is irrelevant. The child is a minor, so please remember that. Rule number 15, for the purposes of the exams. Issues governed by laws that vary widely across states cannot be tested because they vary through different states. So rules for elective abortions, minor, and spousal rights differ by locality. And legal age for drinking alcohol, for example, also varies by state tremendously. So this is questions and areas where we cannot be tested on. Rule number 16 has to do with the Good Samaritan laws that limit liability when physician helps at accidents. Remember, you do not have to stop to help. If you do stop, you are protected if actions are within physician's competence. This is super important. You don't do stuff that you don't have the right to do. If you're not a surgeon, you can't do surgical procedures, for example. Standard procedure is performed. That's number 2. It has to be the standard procedure. And then number 3, stay until relieved. You have to be there and stay until the ambulance comes or some paramedic comes. That's also super important. And then number 4, there is no compensation in the matter. Please be careful about this. In order for these Good Samaritan laws to occur, all 4 conditions must be met. If they are met, physicians are fully shielded from liability. Be careful, compensation is very important. Compensation is any payment, including gifts or meals. So if you get a meal or a gift from somebody's family after you did something, you are not shielded by a Good Samaritan law. Also remember what I mentioned before, the procedure or the life-saving procedure that the physician does, the provider does, has to be within the physician's competence. Standard procedure also has to be performed. It has to be the standard of care. If it's not the standard of care, you're not covered. Rule number 17 has to do with confidentiality. Confidentiality in the United States is absolute, and I stress this again because in other parts of the world, confidentiality is not as absolute. You talk about the patient's condition with other members of the family, and they want you to. Culturally, though, and legally here in the United States, you cannot do that. So, do not tell anyone about a patient. Watch where you get a consultation. And remember, a subpoena does not remove confidentiality. Now let's talk about these a little bit more specifically. Physicians cannot tell anyone anything about their patient. Even if an insurance company calls you and asks you about it, you cannot do that without the patient's permission. If the patient gives you permission, then you can do it. Physicians must strive to ensure that others cannot access patient information. So you guys all remember all this HIPAA stuff. If you're in an area, you got a clinic, and your nurse goes out and yells patients' names and they talk about their condition, you're violating confidentiality. You have a legal obligation to protect the patient. You could get into trouble. Getting a consultation is permitted, as the consultant is bound by confidentiality too, just like you. However, watch the location of the consultation. If you send it to the wrong area and people see that the patient has, for example, HIV or some other condition, you're breaking confidentiality. You're breaking HIPAA regulations. Be careful not to be overheard. I can't emphasize this more. Please be careful about the elevators or the cafeteria. There's questions about this issue. Physicians should never talk about patients in the elevator or the cafeteria. If you receive a court subpoena, show up in court, but do not divulge information about your patient. Confidentiality is still pertinent with a subpoena. Okay, so when do we break confidentiality? Only break confidentiality if threat of harm to self or others. Then we break confidentiality to protect the patient or others. Specific harm to specific person, we break confidentiality. And if infectious disease is a threat. So let's talk more about these issues specifically. If a patient is a threat to self or to others, the physician must break confidentiality. Remember the Tarasov case, you have to do that to protect other people. Duty to warn and duty to protect, the Tarasov case, very, very important. A specific threat to a specific person, you have to protect that person. Suicide, homicide, and abuse are obvious threats. You have to protect those people. Infectious diseases should generally be treated as a threat. But be careful here, because the issue here is usually getting the patient to work with you to tell the person who is at risk. So very, very important here. If you get in a very bad report with the patient, you won't know who really is at risk. In the case of an STD, the issue is not really whether to inform a sexual partner, but how they should be told. Best advice, have a patient and partner come to your office. That's probably the easiest way to do things. Rule number 18. Patients should be given the chance to stay do not resuscitate orders. And physicians, once they do occur, they should follow them. Not only in the hospital when they're in terminal care, but especially when they're in the outpatient setting, you should give the chance to state DNR orders. Remember, do not resuscitate refers only to cardiopulmonary resuscitation. You continue with ongoing treatment, for example, antibiotics, chemotherapy, and stuff like that. DNR decisions are made by the patient or the surrogate, nobody else. It is best to have DNR discussions as part of your first encounter with your patient, especially in the outpatient setting, when he or she has a more calmer environment to think about it. Very, very, very important to discuss early about do not resuscitate orders with the patient, especially in the first encounters. Do not ask the patient about do not resuscitate wishes. You explain details of what is entailed. If you don't explain to them, then they get worried that you're going to withhold therapy. You have to explain to them what this means. Rule number 19 has to do with committed mentally ill patients. Committed mentally ill patients retain their rights. Committed mentally ill adults legally are entitled to the following. They must have treatment available. They can refuse treatment. Doesn't mean because they're mentally ill they can't refuse treatment. They can refuse treatment. They could command a jury trial to determine sanity. They lose only the civil liberty to come and go. They retain their competence for conducting business transactions, marriage, divorce, voting, driving. Very important to remember all this. They like to test issues about a mentally committed, mentally ill patient. Can they refuse treatment? Can they refuse cardiopulmonary resuscitation? Of course. This is part of the rules and regulations of managing committed mentally ill adults. Remember, they all are entitled to all these, especially to refuse treatment and have all standard treatments available. Rule number 20 has to do with detaining patients to protect them or to protect others around them. Emergency detention can be effected by a physician for 48 hours, pending a hearing. A physician can detain, only a judge can commit. With children, special rules exist. Children can be committed only if they are in imminent danger to self and or to others. Rule number 21 has to do with removing from patient contact healthcare professionals who pose risk to patients. So this is a very important area. Types of risks for removing physicians from patient contact are things like infectious diseases like tuberculosis, substance abuse. This has been tested many times of physicians under influence of substances. And then there's depression or other psychological issues. And then there's incompetence. Incompetence is another big one. So they say, what if you know of a physician who is incompetent? What do? Actions here, basically, you tell them to take time off, you contact their supervisors. That's just a very minimum of things that you have to do. Remember always that the patient, not the professional solidarity, comes first. It's very important because there's been cases where people were incompetent or were using substances and harming patients, and because they were physicians, people didn't want to make them lose their privileges, their rights to take care of patients, and would go along with all this. And remember, the patient always comes first. If there's any risk to the patient, you have to act, or you get in trouble. So very important to focus on that. Rule number 22 tells us that we have to focus on what is best ethical conduct, because ethical conduct is much more than the letter of the law. So we focus on what is the best ethical conduct, not simply the letter of the law. The best answers are those that are both legal and ethical at the same time. Not the minimum the law requires, but the maximum that ethics demands. That's what medical professionalism is all about.